Procacci versus Town of Hempstead. And then we'll conclude after that with number 16, Botho versus Urbana. Now, you're pro se on this.
Yes, I am.
Right? Are you an attorney or not?
No, I'm not.
All right. Just so you're aware, we have a loose policy here that we don't ask questions of non-lawyers that come in and argue, so I want you to understand that. So you're here to just tell us why, the reasons that the court below got things wrong.
Thank you so much. Good afternoon, Your Honors. May it please the court, I am Felix Procacci, the pro se applicant in this matter. A plain reading of the Freedom of Information Law shows that Section 89, 4B, does not specifically limit judicial review to the denial of records only. Since the Committee on Open Government has no enforcement powers, as it is defined by Section 89, paragraphs 1 and 2, the respondent's assertion that FOIL is somehow analogous to insurance law is wrong. Respondent brief, page 21, because there is no official like the Superintendent of Insurance that enforces any provision of FOIL. Also, Section 34 of insurance law specifically says that certain sections are declared to be subject of judicial review. The reason why Section 34 was added to the insurance law, as stated in the appellate court's decision, was because the superintendent and the Committee on Insurance Law Revision determined that judicial review is not appropriate for many actions. There is no similar section in the Freedom of Information Law. The respondent concludes that the limitation of judicial review to the denial of records is implied. He states this on page 21 of his reply brief. That contradicts the statement he made in his motion to dismiss on page R96 and the lower court's ruling on page R7 that this limitation is specifically stated in law. Both interpretations are wrong. All provisions of FOIL are enforced solely by the people who make FOIL requests by initiating an Article 78 proceeding in state Supreme Court. Consequently, the respondent's argument that the petitioner does not have an injury in fact, respondent brief page 22, is wrong, since the petitioner is solely responsible for ensuring the provisions of FOIL are complied with, not any government agency or government official. It also follows that the lower court's assertion that any violation of the provision which requires FOIL appeal information be sent to the Committee on Open Government rests solely with the Committee on Open Government is without merit, page R8, since this committee has no enforcement powers. If this court concludes the petitioner appellant does not have standing, then no one has standing, which essentially renders this provision unenforceable and void. Such a ruling would beg two questions. First, why would the state legislature put this provision in law if they did not want it to be enforced? And second, why should a provision of law be rendered void unless it is deemed unconstitutional or conflicts with some other law? In regards to the town's open meeting law violations, it is clear the lower court did not properly evaluate all the facts or interpret the relevant law correctly. First, even if one were to assume the respondent's loophole interpretation of Section 103E is correct, the lower court did not apply it correctly because the respondent never asserted it was not practical to post the associated records for each individual resolution, page R8. Most notably, the petitioner showed the lower court that the resolution number 73 contained a single expenditure, and the respondent did not assert it wasn't practical to post this single-page record associated with this resolution. Second, both the respondent and the lower court incorrectly treat the 3,800-page FOIL responses as if they all related to a single resolution, pages R110 and R8 respectively. Third, the lower court incorrectly states the FOIL records were not provided to them on page R8. This is not true. Links to these records were provided on page R270, and summaries were provided on pages R258 through R269. The respondent never contested the veracity of these records, and the lower court did not consider these records in its decision. Fourth, the lower court only considers practicality as the only possible reason why the town did not provide the reference records prior to the January 5th meeting. The lower court never considered the real possibility the town wanted to hide this information from the public, on page R252. The evidence presented to the lower court shows that resolution number 73 only contained a single expenditure, R245, on a single page, appellate reply brief, page 3, yet it took nearly 13 months before the respondent provided the single-page record to the petitioner. Fifth, if the lower court had viewed these records, which were provided to them, they would have seen that many records provided were dated after the January 5th meeting, so they could not have been reviewed by the town's COVID-19 committee prior to the meeting, the January 5th meeting, as stated by the respondent on page 12 of his reply brief. Finally, the respondent's assertion that the town was not required to provide these records prior to the January 5th meeting because they were not discussed during the meeting, respondent brief, page 13, is without merit because it violates the literal meaning and intent of the law. Using the respondent's interpretation, only records discussed during a meeting would require the town to provide reference records prior to the meeting. The problem with this argument is there is no way of knowing prior to a meeting whether a particular resolution will be discussed. In conclusion, the petitioner has provided irrefutable evidence the lower court failed to review material facts, failed to properly interpret and apply the law. It appears the lower court copied many arguments from the respondent's motion to dismiss, almost verbatim, without checking if they were accurate, and did not address any of the opposing arguments made by the petitioner. For the foregoing reasons, the lower court's ruling on these matters should be reversed and the law be properly applied. Thank you for your attention, and I will be happy to answer any questions.
And thank you. You asked for 10 minutes. You took exactly 10 minutes.
I took 10 minutes?
You took 10 minutes. Yeah.
I usually did this in 6. Thank you.
Well, today was 10. But good morning. Good afternoon, counsel.
Good afternoon. May it please the court, Stephen Martyr for the respondent. The appellant cannot compel the town to submit appeals to the Committee on Open Government. If the court were to find that he has standing to do so, it would be essentially creating a new cause of action for appellates. Every time a FOIL appeals officer fails to CC the Committee on Open Government, now there's a new cause of action. Now someone's going to be running to the courthouse saying, look, there's a failure to file an appeal with the Committee on Open Government. Now I have a violation of the open meetings of FOIL, and now I need redress in the court. There is no damages created as a result of that. It's a administrative filing with the Committee on Open Government. As for FOIL number 2021-7362, that cannot be litigated herein. It was not a part of his original petition nor his amended petition, that FOIL request. He commenced another Article 78 related to that FOIL petition, which is still pending before the courts. As for the compliance with Public Officers Law 103E, this was regard to a January 5th, 2021 meeting. At that time, the FOIL statute provided, open meeting law statute provided, to the extent practical as determined by the agency or the department. Subsequently, later that year actually, the legislature amended it, closing what they called a loophole, and struck the words as determined by the agency or department. That was struck by the legislature. It now says within 24 hours prior to. That, though, was not the statute at the time of the January 5th meeting. However, even if under the new statute we were to take a look at the actions of the town, it's still to the extent practical. It's not practical for every time a town has a resolution with regard to expenditures to post every single one of the expenditures. Now, this was a series of resolutions passed regarding CARES Act. They were all passed at once. One of them had one page. The rest of them had hundreds of pages, 3,800 to be approximate. The town does not go through because the statute also says that is scheduled to be subject of the discussion. If the town board members are not looking at each and every single document, they don't plan on discussing every single document, they should not have to post every single document. as such, the lower court should be, the lower court's ruling should be affirmed. There's no other
Thank
question.
you, Mr. Martyr. And thank you.
There are some errors in, that's outside the record when he talked about the committee and
Misstatements.
the misstatements, sending the appeals to the Committee on Open Government, that's outside the record. He never made that argument before. He made a different argument that the Committee on Open Government has sole responsibility for that enforcement. That's not the case. He never addressed that. The court just followed his lead, and that's an error. As far as the loophole error that he discusses, as I said, the loophole, if there is a loophole, it's I'm saying, the town is saying, it is not practical to do something. They never said it wasn't practical to do it. And the 3,800 pages, as I stated, were never evaluated properly because well over 1,000, if you go through it, and I have the links, were dated after the January 5th meeting, so they could not have been reviewed by the town's COVID-19 committee. So the opens meeting law issue, so the 3,800 pages is a question as to whether most of those records, if the court goes through them, have no relevance to the expenditures. They had time cards, they had correspondence in it. Right. They didn't focus on the expenditure side, and I discussed this all in my brief.
Mr. Martyr, any brief rebuttal necessary? Okay, thank you. Thank you both. And finally, for our most patient attorneys, I guess one attorney